Legally Speaking with me, Tarun Nangia. Today we discuss a very, very interesting topic that we have, of course, of every few years we take up, which is called the economic impact of courts' judgments. Very interestingly, whenever courts give judgments and the wide powers that the court have in India, it has an impact on millions of people. Sometimes the impact also goes to billions of dollars. Delay also accounts for a lot of financial impact on the companies and livelihoods also. And that's why this is the issue we take up today. And this came out after our last show was mentioned in a Cuts International report. The report was financed by Niti Aayog, where Justice Sikri's famous Shiv Shakti sugar mill judgment was mentioned, and in which Justice Sikri highlighted that the court must avoid particular outcome which has potential to create adverse effect on employment, growth of infrastructure, economy, or the revenue of the state, and keep the economic impact and effect of decision in conscious understanding. A very well-reasoned judgment which is quoted time and again. And first of all, let me start by welcoming our panel. We have Justice Arjun Kumar Sikri with us, served as Judge of the Supreme Court of India, now is one of India's busiest and leading arbitrators. We thank him for his time. We have with us Dr. Abhishek Manu Singhi. He needs no introduction. He's third time sitting member of parliament, member of many parliamentary committees, famously the Standing Committee of Home, which he chaired recently. Of course, he served as the Additional Solicitor General of India and is part of the Congress Working Committee, which is the apex body of the Congress party. But more than all, we all know him as one of India's busiest and leading counsels at the Supreme Court of India. Any big matter, we are sure to see Dr. Singhvi's name on one or the other side. Good to see you, sir. I have with me Justice M.M. Kumar. He is India's first president. He served as on the National Company Law Tribunal, where cases amounting to billions and billions of dollars were settled, the dirty dozen as we called them then. And he had a very illustrious tenure, and NCLT's graph that time had shown great strides under his, when he was at the helm of affairs. And Dr. Singhvi would vouch for it. I think he got to argue many of those leading cases that time. And he joins us and will lend his expertise on this topic. Good to see you again, sir. At the outset, I want to highlight what Amitabh Kant, the then CEO of Niti Aayog, which Niti Aayog also financed this cuts report, which we are discussing today. He said in the Mopa airport issue of Goa, which he mentioned that Supreme Court is treating environment and economic development as binary, and stopping critically important projects such as Mopa airport can irreparably harm the investor confidence and foreign investment. So what Justice Sikri said in Shiv Shakti sugar mill, and this is not too much different. And later, of course, the Mopa airport was allowed, but it was a 2-year delay and cost escalation of 38%, which is from 1,900 crores to 2,600 crores. But we will go to the expert, Dr. Abhishek Manu Singhi, sir. If you could give us a few examples, and then we can move ahead to Justice Sikri for conceptual clarity on these topics. Once you give these examples, over to you.
Well, by the way, Arun, in a lighter vein, it was a great mistake for Kumar to demit office. Had there been some way of having a mandamus to have him continue, it would be better. I say it, things are not quite always the same in that tribe, and we miss his days there. But coming to your important question, you have mentioned the Mopa airport. I have had the privilege or the misfortune of appearing in most of these major cases. And recently, it was interesting. Somebody asked me to write the first foreword in a book called Supreme Court and the Economy.
Oh,
He's an expert who does this analysis, CUTS, cuts. It was one time I had called him the Ralph Nader for the Indian system. And he's done a very interesting analysis, and I wrote the foreword to that. So that's why when you asked for this program, it became very topical. Now just consider these examples.
Sorry, I'm just interjecting. I have read your very hard-hitting foreword also of that.
Of course, it deals with Justice Sikri, Shiv Shakti and other things. Not my fault, the book is etc. But the important question you raised, Tarun, just see this, because the question should be linked with, yes, the court should have intervened in these examples I'm about to give, but whether it could have mitigated the damage to the economy. Nobody's saying that this judge finding something human rights, finding something corruption, finding something to do with XYZ cannot or should not. But do they ever think or should think how to calibrate and mitigate the damage to the economy? Now, just let me give you a few examples. And the first example will make the point that there was mitigation possible. But because of lack of awareness, lack of advertence to issues like the one you are raising in your program, the court adopted frequently a blanket approach. And a blanket total approach causes more harm than good. Take, for example, the copper plant of Sterlite at Tamil Nadu. Unfortunately, most of these cases have appeared in it. So don't misunderstand me. I'm not talking about my appearance or the merits of my client's case, but I'm talking about the larger issue. Now, no doubt there were environmental problems, but we also know it was partly a political agitation by people, etc., etc. So very well you closed it. Did you think of any way of starting it again? It can't be a permanent closure. By any court can't intend that there is a problem, we must fix the problem. Do you know the non-starting of it? In fact, recently the application was allowed to just rehabilitate it because 5 crores losses per day. But do you know 30,000 employment?
30,000.
30,000. Valued at only salaries paid to their employment at 146 crores. Lost to ancillary service providers of 1,400 crores. These are just one example. Now, you never thought, you said, okay, this is an all or nothing approach. There's something wrong legally. Bang, thing must stop. Take, for example, many other cases. You mentioned MOPA. But take, for example, the liquor ban on the highways incident. That's, in fact, the first example taken. I argued that case in 2016. Just yesterday or day before yesterday in 2024, it's been lifted. Now, you talk of, India can beat Spain in tourism. India can beat our Kerala and Rajasthan alone, 2 states can beat most European states in tourism. But can you beat them in tourism if you have 2 miles, 500 meters, 1 kilometer from the periphery of a highway? It virtually includes the whole hinterland. Now, these have all been lifted. The court has taken action, but it's too little, too late. Let me give you 2 more examples and end. This is an egregious example. I happen to appear in the BS4 vehicles case. Now, BS4 vehicles were supposed to come in from 1st of April 2017. No problem. The court mandated it, and it's good for our environment. But the court was told that when from 1st of April, April Fool's Day 2017, you will start BS4 only, you must allow a little bit of a window to sell the old stock, the inventory, which is not BS4. Nobody is going to manufacture after 1st of April. Nobody will put into the pool also. There are inventories and cars are not made overnight. Cars can't be backdated. So allow the inventory. Court passes an order on 29th of March 2017 saying, A, you shall not manufacture from 1st of April, but also you shall clear all the stocks you have before 1st of April in 2 days. The stocks were, I have the figure because I paid to get 17,300 crores rupees worth of stocks, 8.24 lakh units. Now, a company can do nothing else except, on pain of contempt, destroy the stocks, lay off the labor. And you cause what? 2G, an extreme case. There was illegality. First come, first serve was abused. But do you know there were 122 licenses involved? Everything was cancelled. There were a large number there, which were 2 categories which need not have been cancelled. That's the doctrine of mitigation. 85 were per se ineligible. They were rejected in the process itself. And many of the others, proven that they got no benefit. There were a few bad apples. You had to cancel the few bad apples. But most of the people who also got cancelled in the blanket approach were people who had not benefited at all in any manner. And the court records that. So I could go on and on. And lastly, these are all cases where the awareness of the court in mitigating, minimizing, not having a blanket approach. And for that, it is not that the court is supposed to know everything. They must ask for inputs.
Point very well taken. We'll go on to Justice Sikri, and there is a comment that he made, which has been reproduced in the report, that while analyzing 2 more cases, is the Goa Foundation versus Cesar Steelite case, and the Tamil Nadu Pollution Control Board case, of which the copper which you mentioned. On the point of law, Justice Sikri said that though a challenging task, it is the duty of the judiciary to strike a balance between the environment and development. Courts should be conscious of the adverse effect of stoppage or delay of projects that will have on the economy. Projects can't be stopped only on the ground of humanity. Now, sir, if you could extrapolate, what is the underlying theory on which you based your analysis? Because whether the current commercial arbitration which you do, or you've served as a judge of Supreme Court of India and earlier the Chief Justice of a High Court, what theories have developed which has led to this understanding and what you've said? Could you just explain it in detail?
Okay, thank you, Tarun. And I think Dr. Abhishek Singhvi has given some of these instances where the adverse impact as far as economy is concerned, or the economic effects, adverse economic effects are concerned, those have been elaborated in all these examples. If we go theoretically or jurisprudentially, actually what I feel is all economic analysis of law. Law is there in the statute book. When we talk of 2G cases or coal, I'm keeping aside for time being, but these cases, if we remember, these are that the licenses which were given in 2G spectrum, which was given, or coal mining leases, etc., which were given, they were all illegal, and those were challenged on the ground that, in a way, that comes within the realm of public law or administrative law. So there's something amiss, or there's some illegalities committed either by those who had given the bid, they were not competent or eligible, or they had some favor was done to them while allocating all this. Now, in administrative law, we know that there are certain parameters on the basis of which the courts have power to undertake judicial review of administrative action. Now, I'm presuming, I'm not going into the merits of these decisions, I'm presuming that the court was right, that the action which was taken in either giving the spectrum by the court or coal blocks which were allotted, there were some wrongs committed from administrative law prism or public law prism. Now, the question that arises in such cases is here the economic analysis of law which comes, and what Dr. Singhvi has narrated in simple language, that is mitigation. Now, the question is whether after finding it, that I'm giving the example of it applies to 2G and coal both, after finding that it was wrong act. Now, question is, after so many years, was it necessary to cancel all those licenses and to have a further study to the aspects, as Dr. Singhvi also pointed out, that maybe there are 3 or 4 persons who are culprits, or in those cases, the violation may be very substantial, etc. So, was it not necessary for the court to go into that exercise at that level? And mitigation coupled with the fact, yes, if there are somebody that like these licenses who are there for last number of years, now therefore if they have drawn some benefit, some wrong advantage, then why not have monetary penalties? And so therefore let them continue now, but they will compensate exchequer, and these are the monetary penalties which are given. Same thing could have happened to coal block cases. And let me tell you another very interesting thing. In 2G, the court had directed that a prosecution as well. And ultimately, and we all know those against whom there was a prosecution, they were arrested, they were not granted bail for 7 or 8 months, after 7 or 8 or 9 months. Bail was granted to some of these persons, but ultimately all of them were acquitted in the criminal case.
Discharged.
So what happens after 2 or 3 years, and what is the effect of that on the business of those persons who were behind jail? And many of them, the business could not even thereafter, they could not revive that. Though what I'm trying to make, sorry.
See, one thing that I would like to point out here is that two examples in which I and one Dr. Singhvi gave. In the Mopa airport, the CEO of Niti Aayog, Amir Khan, took it up. Mr. Kant was very vocal. GMR, which was a concessionaire for that project, got a 2-year extension. Now the project is operational. The Mopa airport, which was to be operational in 2020, got only opened in 2022 end. It went from NGT to Supreme Court. Or in the second, the copper plant place, it is still going on in courts. It's been 6 years. In your view, is there any way to speed this procedure? Because to get from $3 trillion economy to a $6 trillion or a $10 trillion economy, if projects are stuck in court, cases are stuck in court for 6 years, businesses can get ravaged and banks can go bankrupt because no money will be paid back to the banks. And 30,000 people will lose their jobs, like in case of the plant. Can you explain this?
So, you see, in Shiv Shakti, I cited Ronak International, where the court was conscious of the fact, I think Justice Kirpal and Justice Sujata Manohar at that time, who were the members of that bench, they refused to grant the stay against a project. This petition was filed that it is wrongly awarded and all that. They said we cannot grant the stay because we will keep in mind this fact that if because of the stay project is delayed, ultimately, what is going to be the cost? So the reason for which we had that precedent before us, and the reason for which the stay was refused, that didn't happen in Mopa case. And as you rightly mentioned, ultimately after 2 years, the stay is lifted and the cost has gone up by 33%. Whereas the Supreme Court has earlier said many years ago in Ronak International. So what I feel is, in such cases, there are only two ways. And I'll give you example in intellectual property matters, the way jurisprudence has developed in India and the way it has happened in America, which I have studied closely. And that also may be an aspect of economic analysis of law. I'll come to that. The number one, either in such cases, there should not be a stay immediately or in between when there are big projects are involved. What the court can put down certain conditions can, at the risk and cost of the successful bidder who has got that, tomorrow if we feel that the contract awarded to you is wrong and it is nullified, then you bear the risk and cost, but you can go ahead in the meantime. But at the same time, decide these cases immediately and the earliest possible, where the stakes involved are high and the projects are in national interest. They have to go ahead. And as you rightly mentioned, when we talk of 5 trillion, 6 trillion or 10 trillion economy, all these aspects have to be taken in mind. So that is one way of looking at it, and that is also may act as a mitigating factor. Actually, I tell you, it's a very, I'm now giving you that example of intellectual property, which I said it immediately came to my mind. But as the jurisprudence on intellectual property of interim orders, etc., which has been developed in India is totally contrary to the way it has developed and the judicial decisions which have come in America. Now, what happens if there is a violation of some trademark, copyright, patent, etc., and the person who says that the other side defendant is violating my right, then they come to the court. And at the same time, they move an application for injunction that other side should be restrained. Now, as I have understood, there are normally two kinds of cases. There may be a case of counterfeiting. I give you a simple example. I'm fabricating, say, jeans, and I'm selling it as jeans which are, say, Boss mark. And of course, it's a clear case of counterfeiting. I have no right to adopt that trademark with the mark of as if it is fabricated by boss and sold as boss. That yes, injunction can be given, but then there may be some cases where it is not, and particularly in patent cases, where it may not be clearly visible at that time at interim stage, whether the defendant is violating the patent of the claimant or the plaintiff in manufacturing a particular item. Now, here in India, what we do is, and of course, this is changing now, but in last 20, 30, 40 years, whether injunction should be given or not. And that matter can go up to Supreme Court. If you find most of our judgments where law is developed are only on injunction, Order 39, order passed in 30, 40, 50 pages. And injunction is given, other side may be totally out of business at that time. If it has committed some wrong, and as I've said that it's a clear case of violation, yes, you can do it. But what happens in America, they don't give injunction at that stage. They fast track the case, but at the end of the day, when ultimately it is found that there was a violation of patent, then the damages which are given, monetary damages are given, they are exemplary. So the person is punished at the end, not in the beginning itself, and ultimately it is found that no, he had not committed any violation. So therefore, I'm not going into IPR. I'm saying that is the philosophy which may be required while undertaking these kinds of cases.
Point very well taken. First, you said fast track these cases, award exemplary financial punishment, but don't hold it up. Very good point. I'll just go to Justice M.M. Kumar. You have a unique experience of seeing cases from the National Company Law Tribunal end and as a Chief Justice of a High Court. I want to know, in these two cases that we brought up, the Mopa Airport where GMR got 2 additional years and the cost went up by an X amount of number, or if a plant like say the copper plant there in Kudi, it's been shut down. Do you think, what is the risk? Do you think that the companies can go bankrupt and via NCLT are then bid out to others? There is a livelihood risk there. How should court look at issues of financial importance in your view? Since you have presided over the NCLT, could you share your experience from that vantage point also?
Very well. Thank you, Tarun. Justice Sikri and Mr. Singhvi have elaborately explained. In the National Company Law Tribunal, during my time, the delay was not as much as I am hearing these days. Large number of resolution applicants who have been cleared by the Committee of Creditors, they are waiting clearance from the National Company Law Tribunal. And eventually, after 2-3 years, they are fed up. They file application for withdrawal of their resolution plan for the reason that the prices have gone upside down. The property for which they have given the resolution plan, that property has diminished in its value for various reasons. So therefore, although the Supreme Court in Exim case have held that resolution applicant cannot be permitted to withdraw the resolution plan, but the economic impact is such. A resolution applicant is forced to go back. Then, instead of challenging the commercial wisdom of the Committee of Creditors, he tried to highlight various violations committed by the resolution professional. He tried to bring in the legal violations which are within the jurisdiction of the National Company Law Tribunal. So such is the position going on because of the delay. One remedy for curbing the delay is the statute have laid down the limitations that 180 days to start with, 60 days allowance, then not more than 260 days. That is or some variation but this is the time limit given. This must come to an end. And delay is the culprit. Whether we talk of Goa airport case or Madras case, that is how to curb the delay. The issue before us is how to curb the delay. As Justice Sikri rightly mentioned, that one party obtained interim order, then it continues for many months, many years sometimes. And litigation go up to the Supreme Court. Under Order 39 order go up to the Supreme Court. Firstly before two judges, then before Supreme Court, then come back before the adjudicated court again. So how to curb the delay? One is, IBC is a very, very specialized branch of law. And repeatedly, the members are dealing with the same issue. There should not be any difficulty in bringing more efficiency. Because if you are dealing with proposition under the company's law or under the IBC, how many types of cases come before the NCLT or NCLAT under the Companies Act or under the IBC? Section 9, Section 7, or liquidation, or under the Companies Act, merger, demerger, 230, Section 230 onward, or 241, mismanagement, or 52, the closure of the companies. So these are the nature of cases, broadly speaking. So if NCLT, which is an expert body, assisted by technical members, they have been entrusted with this task. They can bring more efficiency. More members can also be there. Delay part has to be curbed somehow or the other.
Point.
The second is, now we are talking of 2G spectrum. 2G spectrum was a case which at that time, the narrative was created that 1,85,000 crore, the Comptroller Auditor General at that time raised that type of narrative. And naturally, when the report came before the judges, they thought that the public exchequer is being looted. That is the thinking of that time. And instead of having an open auction, they are allotting sitting in their offices. First come, first basis. So that criteria did not appeal to the judges at that time. They said no. Then 5 judges bench opinion was sought by the president, whether in policy matter it could be done or not. If there is a policy with regard to natural resources, that was the reference made by the president. So 5 judges answered that reference. So today we can be wiser, no doubt. And the second thing is, in England, whenever a bill is introduced, it carries with it economic impact assessment on the infrastructure, on the manpower, etc., etc. The economic impact by virtue of bill, which would be coming on the public exchequer, that is assessed. We can have something like that. As I said in my previous program, we have to have the experts who may be able to assess the cases, or Parliament in all the statute can limit the power of the court. Power of the court that if it has economic impact, you will not grant stay order. You will hear the case on priority basis. Justice Kapadia, I remember in tax matter, he said, be slow, don't grant stay. Justice Nariman also, in IBC cases, said, no. When he was examining the constitutional validity of the IBC, various provisions of the IBC, Justice Nariman said, no, we should be very, very slow, even while examining the operational creditor, financial creditor, that distinction. They were just
Point very well taken, especially on the economic aspect. You said the cases should be fast tracked. A lot of promoters and a lot of businesses in India will identify with that. I'll go to Dr. Singhvi before you go on and share some other anecdotes with us. 2 points that you raised in your earlier answer on the Mopa airport, the Niti Aayog CEO took up the issue. Then it was remedied, but of course GMR got 2 extra years and the infrastructure development was delayed by 2 years. But the case took a lot of time till it reached the Supreme Court. In the copper plant issue, I just Googled to find out that India turned from a net exporter to a net importer of copper. So basically exactly reverse, and we are losing foreign exchange every year. Do you think in such issues where the country's foreign exchange is at stake, or you turn a net importer, the government should also show a certain interest in getting things resolved when the country's interest is at stake? You're not audible.
There is absolutely no doubt that larger macro issues must require the government and the courts to look into it on a macro basis. Now, there are 3 or 4 or 5 points I want to make very quickly. First, just to add to the earlier round of, and then I'll come to what you asked. I forgot to mention, and these are the devil and God lie in the details. Each of the examples I gave, I believe, the same result of upholding environmental or human rights or anti-corruption concerns could have been achieved along with the minimization and mitigation of damage. A striking example of that is the coal mines case, the allocation, which we all discussed. People forget that there were 2 batches in that coal allocation. The main batch was 1993 to 2003, 10 years of allocations. Now, remarkably, nobody, including the CAG, and remember, including the CAG, which started off the whole political dogfight, nor any other committee had suggested that there was anything illegal in the 93 to 2003 allotments. The dispute was actually about alleged corruption and other irregularities in the 2000 onwards, which was about 5 years. Now, this happens when, there is too much of, perhaps media scrutiny, perhaps too much hullabaloo about the case. In that entire examination, the whole lot was cancelled. Now, I have examples of people who were 93 to 2003, where there is no allegation by anybody, including in the ML Sharma case or by the CAG, about any irregularity. They also became collateral damage. Most of those companies went bankrupt. So now, if this kind of focused analysis there, the courts could easily have segregated. They could have tailored the relief. There are enough tools. But the courts sometimes either don't get the assistance or indeed don't ask the right question or indeed are driven by a media glare. That's point 1. Interestingly, of course, the point Justice Sikri made, I was in the lead batch of cases which argued before the special CBI judge. And after 10 years or 8 years, we got a discharge. Forget acquittal. We got a discharge. That matter is not complete, but that's a footnote. Now, number 3, I think it's important that one part is the injunction thing. That is the malaise of the entire Indian system. The injunction being larger than the final relief, the mini trial being much more important than the main trial, is the place of the system from beginning. And in fact, we are worse because we have the bigger trial going to the Supreme Court at least at 3 levels. Now, that will take time, but certainly now that you have fast tracks and special tracks in some high courts, for example, IPR, etc., arbitration, etc., there is no reason why we can't change our ways. There is no reason why we can't start fast tracking the trial. And in appropriate cases, as Justice Sikri rightly said, where there is an absolute res ipsa loquitur on the face of its situation, you can grant an injunction. But where there are fast tracks available and can be done, judges hands-on should do it. And that will make a sea change in the approach. I also want to make a few conceptual points, because these are actual live examples. What lessons do we draw from that? One is, of course, along with the very good idea of the EIA, the Economic Impact Assessment, we only have a financial memorandum. In fact, we have to have 2 assessments. both of which we are regretting now. We have come full circle, by the way. In Parliament, we are discussing how to minimize or even repeal 498A and 138. This is typical India. You first bring in the baby with the bathwater, and now you want to throw the baby out with the bathwater. Why? Because when you enacted 138 or 498A, one assessment is economic impact, which we're discussing today, but you also did not do any judicial impact analysis. That one piece of legislation, how much cases it will generate.
How much
today,
infrastructure will be required?
The two biggest cloggers of our arteries in the bypass of the heart system are these two categories I just mentioned. Now, therefore, this analysis must be mandatory. So every bill which comes to me as a parliamentarian has a financial memorandum. It doesn't have either a judicial impact assessment, what I call a GIA, which I've talked about in Parliament, I suppose, nor does it have the EIA, which Justice Kumar talked about. Why can't we do it? It only means a little bit more work and patience for the bureaucrat. It means you can't bring in knee-jerk bills without doing the homework at the end. Thirdly, I think there has to be also a greater intellectual humility in the whole system, in lawyers and in judges, to call for intra-proceeding expert reports and, more importantly, post-judgment external audits.
Yes.
Justice Kumar has given a good judgment. Justice Sikri has given a good judgment. Justice Nangia has given what is considered a okay judgment, not too good. Mr. Singhvi has given a bad judgment. Now, these four paradigms must be examined after the judgment by an auditor. How much on the ground in the next 3 years the effect was of Justice Kumar's judgment, Justice Sikri's judgment, or Mr. Singhvi's judgment? That is not done. We have, of course, this kind of book which I have just showed you has done some analysis in some 8 or 6 selected cases. But this should happen much more, because that's a feedback. Court did very good in CNG. What was the ground reality? You have to work it out. I'm now talking of pure expert statistical, technical audits, not judicial, by management experts. That will be a remarkable feedback for people to act in the future. And that comes with a certain amount of cooperative things and also intellectual humility, not a pomposity which is unilateral. It has to involve different people. So I think these things, awareness is the biggest. And lastly, the Indian Supreme Court is by far the most judicial review-oriented court in the world. I always say that it will make Marbury Madison blush compared to what we can do. Marbury Madison is not even a blip on the radar. Now, with greater judicial review powers, with PIL inventions, which are great, with basic things, which is pride of India and the envy of the world, along with that comes responsibility. Greater responsibility, greater restraint, greater awareness of the other point of view. Judges, there's a contradiction inherent in the system. The contradiction is judges necessarily have to have a bilateral vision. It's always A versus B, A versus B versus C. Whereas these issues require a macro vision, which is not necessarily A versus B versus C. So the harmonization of the inherent contradiction will come only by an awareness. Now, Justice Sikri or Justice Kumar will sit in a bench. They'll always be aware of the system because we've discussed it so many times. But not necessarily every judge, not the district judge, not even High Court judges, few Supreme Court judges who have had the experience. So this is a sensitization process also required.
Point very well taken. I'll go to Justice Sikri. One thing I want to ask from you is when a case involves implications of thousands of crores, either investment, employment, be it coming via the arbitration process where it is then goes to the High Court and the Supreme Court, or a case directly before. Do you think the courts must devise a system that it gets prioritized in the system, given the large impact it has on the economy of the country? Given that every such judgment delayed or the delay in the court process will make the investor sitting in London or New York think of him putting money into India. In your experience, if you could share anecdotes via the arbitration process or direct court cases in both cases.
Okay. Now, let me tell you first, I'll wanted to say what Dr. Singhvi has already mentioned about the awareness. If you see, and as I have read so while economic analysis or economic impact, etc., is concerned in so many ways, and particularly after globalization here, it is two levels. One is policy level, which we talked about while making the laws, etc., what is to be done. The other is at judicial level while implementing these things. Now, thing is that whereas in many other countries, as I've seen, and particularly in America, where few persons who, I mean, are really who have in a way, economic aspects into the law. They are the protagonists like Justice Posner, etc., who have really spearheaded this movement. And it is the awareness has come. In India, if I have seen the history of the case law and the cases and the how judges subconsciously, while making a decision, we may have taken into consideration the economic impact. But whether consciously, the way this kind of awareness, which Justice Dr. Singhvi has said, whether it has come, I feel that it has yet to be generated as far as judicial fraternity is concerned. And I feel that there may be, we have our judicial academies, there may be training of the judges in these aspects. I give you now example, what you said, anecdote. After now coming on this side and doing arbitrations, I found a very interesting thing that whenever, suppose it's a construction project where there is a delay. Now, because of the delay, the contract comes and he says that delay has, because of the owner, the delay has taken place, my cost has escalated. So naturally, clearly, economic impact insofar and as we have given the example of that GMR. Suppose GMR tomorrow files a case against the airport authority and says that, look, my cost has escalated by 33% and you pay it, and arbitration starts. Now, what happens in such cases is that we go into the economic aspects and how delay, both parties may accuse each other of the delays. The employer or the owner may say delays because of the contractor, it had not brought sufficient resources, it not sufficient manpower or machinery, etc., and therefore the progress was slow. The contractor, on the other hand, can say that, look, no, sorry, I was the decision which were to be given, good for construction drawings, or other decision which the owner took time and they did not payment also on time, and because of that there was financial crunch, etc., delays on their part. Now, if in the whole project for 2 years, 3 years, there may be, both of them may be partially correct. Now, what happens then? It delay analysis is required. There may be delay of both the parties at the same time, which we call concurrent delays. There may be delays which have no effect at all, because say if the contractor did not give the bank guarantee which was necessary to start the work, then if the land was not provided by the employer, then it had no meaning. Or then other delay which we call in our language are critical delays. It is critical delays which matter. So now it is not easy for us to go into that. Experts come and they give their delay analysis, how much is the concurrent delay, how much is the critical delay, etc., and on that, who is to be blamed, then that is one part. Then on that basis, how much is the economic impact for which the damages are to be granted. So the quantum experts come. Again, they may be chartered accountant, but they may be expert in these things. So likewise, what I'm trying to say is two things. One is as awareness. Why not in such cases, the court, whether it is the High Court or the Supreme Court, have the services of some experts who may come and say that, look, what would be the economic impact of this if it is delayed, or if it, today the project is torpedoed or it is revived after a few years, etc., then what is going to be the impact? Impact is not only in the cost, which you have mentioned insofar as Gopa is concerned, it is not that, because the cost may have gone up, but the indirect impact. For 2 years, this airport could not give any services, or it came late. Then for 2 years there were no flights. As far as that is concerned, maybe it is possible that otherwise many more tourists would have come. It would have generated income for Goa. in tourism, in hotel industry, for other restaurants, etc., hospitality industry, etc. All those indirect losses are also there because of delays. So therefore, the courts can take the help of those who are today awareness, and in that sense, the economic impact. We can, the first, judges should be conscious of this, and secondly, can always take this services of some expert so that they have the real data before them as to where they are going. Like the cases of 2G or coal, even if, as I said, in administrative law, which Justice Kumar also said that decision was right. That's why I started with this. But whether the final judgment which was given cancelling all en bloc, whether that was right, or it was some monetary, penalties, etc., which could be imposed in such cases. So these are the aspects which are to be kept in mind, and they have to be. I think that time has come that there has to be training of judges insofar as economic aspect, and what we are discussing is only on periphery. If we go deep into the economic analysis, there are so many effects, and these may be in so many types of cases, which I have been studying from time to time, writing and giving. And although I'm also totally a novice in this field, but if you talk to economists and the way they come out of these formulas, etc., that it is beyond even our understanding. So therefore, but then that is today needed. And that is very, and particularly when we talk of globalization, and it is not only in these, we are talking of big projects, we are talking, I'll give you one simple example of another nature, totally. Say, in many cases, businessmen, if they have committed some wrong, it may be income tax, it may be FEMA, it may be some other, either ED is after them or income tax department is after them, the businessmen are arrested, etc. Now, I'm simply talking of bail in such a case. Even if bail is not given where because it is an economic offense at the most, so whether at right time bail should be, and the principles of bail which are very clearly there. But then the judiciary should understand non-grant of bail for quite some time to such businessmen who may not have otherwise committed very serious offenses is creating a wrong environment insofar as investment in India is concerned. So therefore, apart from the human right, right of liberty, etc., personal liberty of those persons, when we talk of ease of doing business, is it an act of ease of doing business when we deny bail to a person for 10 months or 5 months or 7 months and he remains under jail? But what is going to be the economic impact? We know many have invested their money now in other countries. Of course, India still is having good FDI, and it is surpassing now China also in certain respects, very good. But it could have been far better also. So therefore, these are also some of the aspects which the judges have to take in mind.
But your theory on economic analysis of law is still discussed, and that's why we discussed the Shiv Shakti sugar mill judgment time and again, and including this report. And that's why these kind of judgments are appreciated long after they've been authored. Now, in so many years, and still, I'll go to Justice M.M. Kumar here. Very quickly, I want to ask you that in cases, say, as the Mopa Airport or say the copper plant, do you think that the government, as it is said, and the courts must take a view where cases of national importance are concerned? What is national importance? National importance is anywhere where countries' finances are being hit, because it could be any case. Do you think that there should be some effort that, if we treat out any case with compare with this case, then it will forever be stuck in courts for 8 and 10 years. The company will be bankrupted and go to NCLT. Somebody else will buy it. The company will run again. But in that process, millions and millions would be lost. Your input on that?
Arun, as I said, the government has made one effort in MSME sector. In MSME sector, they said the borrower can keep the possession if a scheme is prepared and is ultimately proposed before the NCLT. They made this concession for MSME. But how far that is effective? If you start counting cases before NCLT by MSME, there are not more than single digit cases. I mean, there are 3-4 cases which I know the NCLT in MSME sector has decided on the basis of pre-pack. That is what is known as pre-pack. Pre-pack in limited way has been introduced in MSME sector. But the larger question, as you have posed, is to ensure that cases which have real impact on the economy, the big cases, the dirty dozen cases which were known earlier, like those cases which are in the civil court or in the High Court or Supreme Court, what should be done with regard to that? For example, Supreme Court carved out a category of cases critical, the criminal cases against the politician, fast track. We can certainly make effort. Now the commercial courts are there, so the flagging system can be there. Chief Justice of the High Court or in the Supreme Court, the case can be flagged that it has to be given priority. Now, for example, the Chandigarh mayor election, that case was given priority.
Yes.
That case was heard immediately. Because otherwise the whole stream of the argument will go away. So therefore, the cases which are of such a nature, such an urgency, which have huge economic impact, and our reputation abroad is going to suffer. Our ease of doing business, that program is going to be dented. I think the effort should be made to give priority to those cases, and some method be devised to categorize these cases to give them priority. And sensitization, as Justice Sikri had said, sensitization of judges in the Judicial Academy must be there.
Yes.
Because, see, every single case decided by the courts has its impact politically, socially, individually, economically. Every single case. It is what is the court? Court is the representative of the whole society. Every type of case comes before the court. It is a microcosm of the society. So if that is the case, then the most important cases would be which have economic impact, because the economy of the country would suffer, because everybody's per capita income may suffer. As I said earlier, about 6 lakh crore, there were 11 lakh 50,000 crore NPAs in 2016. That was the figure given. After COVID, the whole thing has gone topsy-turvy. Figures are not coming forward. But till the time I remain president of NCLT, we have solved about 6 lakh crore of NPAs. And the then finance minister in a blog have said that rupee value against dollar has gone up because the whole money, for example, Bhushan Steel, 3 cases were worth 1,10,000 crore.
And that was solved under your presidency.
Yes. So once the order came in Bhushan Steel, in 2-3 other cases, the rupee value gone up against dollar because the money was coming from Germany.
You are actually showing how it impacts economy very well.
Yes. So therefore, and those cases during that time, they were finished within less than 180 days.
Point.
1 or 2 cases remain hanging, but most of the cases were.
You're driving an important point. 180 days and the case was finished.
Yes. So therefore, I think it would be worthwhile to have experts, and experts should be assisting the judges, and judges should also be sensitized, and that if you are unable to go further, then take guidance of the expert. Then you can order experts, and there should be efficiency.
In fact, in your answer, I got one more answer. That's why it's important for the Chief Justice of India to be master of roles, because he knows what case deserves priority. Because otherwise, if the mayor issue or the other issue comes via computer system, it will never come.
Yes. No, he's the master of the roles. Every
Yes.
Chief Justice is the master of the role of his own High Court. So
that is why it is important. In fact, in your answer, I got this answer also. I'll go to Dr. Singhvi for a final comment.
Well, I'm glad you gave the example of the Chandigarh mayor. I mentioned it Friday. And clearly realizing that the computers have their limitations and that the matter would become infructuous, both in terms of the content not being preserved. For posterity, there would be nothing left to examine. And they listed it on Monday, and Monday the matter did not reach, but at 4 o'clock it was taken out of turn because there were other matters before, and it was heard till about 4:10. So these are obviously matters which require individuation. Computers are good for general things, but individuation can't be done by computer. But the more important point is, this is the Supreme Court of the Chief Justice of India, which ultimately has a small number of matters. It ultimately has 35 judges. It is the High Court master of the rosters who have to deal with this allocation. And I think the best solution is laying down certain guidelines and rules. One, put different tracks in different categories where there are mega effects, economic effects. They can certainly be put on the fast track despite the delays in assessment. And those cases, if they are already suffering an injunction, faster track. Otherwise, new cases of that category must be limited to a fast track hearing without an injunction. This awareness and the examination of the relative, and of course now in the last 1 year, I find there are 4 or 5 very good judgments of the Supreme Court, but that's again theory. It's the practice by the High Courts and the District Court which matters. But the 3 or 4 judgments in the last 1 year have repeatedly cautioned that tender matters where projects are held up should be very, very carefully scrutinized before any interim order is given. So the trend is there. But it's not a question of the principle, it's not a question of the law, it's not a question of the judgment. It's a question of implementation, absorption, awareness, sensitization. And the other last point I want to make is that ultimately there has to be a system of absolutely unblemished, unchallengeable credentials persons who can act as a panel of experts at ready beckoning and call. Now you see there are 2 parts of this. One is the availability, but the second is equally the credibility. You can't, some of these people have conflicts of interest. Some of these people have lots of other problems. So you need that, a top expert who gives an immediate 1-week report of, let's say, a delay analysis or a cost analysis. Imagine the credibility of that report. It'll be huge, and the court can safely act on it. Equally, if they are just some kind of a general empanelment of people whom you want to do favors to, then there's a problem with that also. That's the problem in India. You need to be very, very careful and very nitty-gritty about these things. But I think the very fact that we are discussing these matters, the very fact that this awareness must necessarily spread through discussions like this, through the media, is going to make a difference. And I think we can just hope for the best.
Thank you so much, Dr. Singhvi, Justice Sikri, Justice Editioin, for making time and joining on the show. We end part 1 of our series, which is the 2024 edition of the economic impact of courts' judgments. In the next part, we'll discuss a few more issues, a few more judgments, and of course, some great suggestions from Justice Sikri, Dr. Singhvi, Justice M. Kumar, especially on fast-tracking these cases, the economic analysis of courts' judgments, Dr. Singhvi's post-judgment audit, and of course, as I always say, like with Shiv Shakti Sugar Mills, if good economically prudent judgments are given, they are remembered years after they are authored, including the author. And of course, the analysis on arbitration that also Justice Sikri shared with us. Really appreciate that all of you joined. Thank you so very much. Thank you.
Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.